If you're an employer, an employee, 1099, a W-2, this is critical that you listen to this episode because you might be getting paid wrong and there could be or paying wrong and there could be huge ramifications. I'm here with Aubrie and Anton Kaminsky from Kaminsky Law. Let's jump into this. Anton, talk a little bit about your practice and how you guys deal with this first, and then let's get into the nitty gritty.
Sure. So we are a litigation firm. We do a lot of lawsuits, and as a result, we wound up seeing a lot of lawsuits for employees and employers that may or may not mischaracterize their employees, have non-compete issues, have payment issues. And so Aubrie has taken on a large portion of that business and that work where she guides both employers on how to properly structure their agreements, how to properly structure their pay and and the way that they, handle their employees to make sure that they don't terminate somebody improperly. And then at the same time, and as a result, Aubrie takes on a lot of cases for employees that were either paid improperly or that were terminated wrongfully, retaliated against. There's a ton of things, and I hope we can talk about them today.
Yeah, Aubrie, tell us a little bit about your experience in the space. I think it's really important to be experienced, right? And if you're in in this area of the law, and then let's jump into that question of the W-2s and the 1099s.
Sure. I've been doing the employment law for a number of years now. It started with our small business clients would need a non-compete or an employment agreement, something like that. And it just kind of evolved from there. We get a lot of employee calls for, a number of different things. And I think most common is they're not being paid. They're being paid improperly, they haven't gotten a paycheck, those kind of things. And the first hurdle that you need to overcome in a wage payment dispute is, are you an independent contractor or are you an employee? The reason this matters is because the wage payment law that you can collect under, if you're not an employee, then you can't sue under that claim. It also matters for tax purposes. You're paying your own taxes. And, if you're doing that improperly, that can be a problem later on. I think the biggest things that we see with independent contractors versus employees, when we look at that, there's no real bright line test. So it's a balancing of a number of different factors, like how many hours are you working for the employer? Are you able to work for other employers? Did you sign a non-compete? Are you using your own supplies? Are you using your employer's supplies? And so all of those things come together and we balance them, and it helps us make an argument for, are you an independent contractor or are you an employee? And the one thing that is interesting about these distinctions is when you sign a contract, usually in contract law, what the contract says is what the contract says, and you can't wiggle around that. But if you sign a contract that says, yes, I'm an independent contractor, that doesn't apply if that balancing test weighs in favor of being an employee.
Got it. Okay, so a couple things I want to unpack really quick. That was really helpful. One, just for vocabulary purposes, bright line test. I'd never heard that before. What is that in the legal space?
So it's bright line or red line is you'll have these elements or factors, and you have to meet every single one. Or if you meet one of these, it is whatever the test is. You've passed the test, so to speak. A balancing test is where no factor is weighted more than the other. They're all kind of looked together as a whole instead of one thing just being the deciding factor.
So in a case of like, are you a W-2 or should you be I should say this better. Are you classified as a W-2 or are you classified as a 1099? It's not the bright line. It's the balancing act. There might be a couple different factors and not one of them necessarily means, oh, you're 100% a W-2. There's a couple different things to consider in that assessment.
Right.
So that obviously adds complication, and people probably need to, I imagine, consult an attorney at the beginning, right? Like if you're an employer, is that part of the practice too? Like, is that or part of the recommendation? It's like, hey, talk to the attorneys before you're deciding who's a W-2 or a 1099.
For sure. if you're an employer, you really want to make sure that you are classifying your employees correctly, because if you are not, there's ramifications for that. So the Department of Labor, if there are complaints made by your employee or independent contractor, they start to do an investigation. And if they find out one of your one of your independent contractors is really an employee, well, now maybe they go digging and seeing how many of your workers are classified one or the other. And, not an accountant, not a tax expert by any means, but there are tax ramifications, because when you're 1099, the employer's not paying those taxes, the employee is. And so that can also be an issue as well.
Right, because that might change the evaluation of those taxes, and then also who paid them and when they paid them, and then back pay. I mean, I imagine there's this big domino effect.
So
Correct.
so what happens is, if you're an employer, you want, if possible, to classify your employees or your workers. Let's call them your workers so we're not confusing the words. But if you are a employer, you would prefer that your workers be 1099s than W-2s. And the reason for that is, number one, you don't have to pay your own share of taxes for them. So when you are paying somebody W-2, they pay taxes and you pay some taxes also. When they're classified as 1099, they're the only ones paying taxes. So you, as the employer, avoid those taxes. So that's reason number one why you want to typically classify people as 1099
Or people
instead
are
of W2.
incentivized to do so.
Right, as an employer is incentivized. Right. The second big reason is to insulate from liability. So if you're a general contractor or you own a trucking company or whatever company that you have that might have a lot of liability, what you want to say is, well, hey, this guy doesn't work for me. He's not my employee, so I'm not responsible. I have a agreement with a separate company, or I have an agreement with him individually. He's his own company. So if he got into an accident or he did something wrong, go sue him, don't sue me. And there are some laws that basically allow the contracting party, so the employer in this case, to get out of lawsuits or liability because they say, well, I don't direct my independent contractors. And so that's, Aubrie did a great job to summarize that. That's where this balancing test comes in, right? Just because you say as the employer that this person's an independent contractor, either the government or somebody that's suing you later might come in and say, well, wait a second. They worked for you full time. You made them sign a non-compete. They were using all of your tools and machinery. They really are an employee. Just because you signed a contract that says they're 1099 doesn't mean anything.
And Aubrie, that's what you were saying earlier, right? That the other thing to consider is that the law doesn't really care what your personal agreement is that you sign with this person. If they pass that balancing test as an employee, you could have the nicest agreement on the planet. It is null and void at that point.
That's correct. Yeah.
Mm-hmm. So really quick, what are the kind of industries that you find that are the most, you see the most issues with in this space? Like in your practice, you mentioned trucking as an example of like a high liability area. What are some of the industries that you see?
I would say construction. There's a lot of independent contractors in that industry, and a lot of them are probably properly qualified as independent contractors. Where I see it kind of being mischaracterized is more in like office settings and, administrative roles, working for a single company, things like that. But I would say like the service industries are more where you find independent contractors.
So we'll see it a lot in home care. Home care is a big one. I would say in contracting, like general contractors will often have their employees characterized as independent contractors when, there's a distinction to be made. Sometimes it's a subcontractor, right? So if I'm a GC and I hire a window guy, that's a subcontractor. I'm not a window expert. I hired a window guy. But if I am a window company and the people that are installing my windows are classified as 1099 independent contractors, chances are that's misclassified. I'm not saying every time, but a lot of the time.
You see that a lot over there. So you see it a lot in office spaces, pretty much that's a wide swath, right? Service industry and office spaces, right? Professional services and office spaces, and then a lot in the contracting space. And you said home care. What do you see there in that space?
Well, in the home care space, a lot of times people work overtime, and they work a lot of overtime. And so this is another reason why, as an employer, you would want somebody as a 1099 rather than a W-2 employee, because if you are a W-2 employee, you're supposed to get overtime. And Aubrie could speak to the overtime in specifics. But if you're a 1099 contractor, you're usually being paid on a project basis or on a weekly basis or on a monthly basis, right? And so you're not taking into consideration how many hours you work. And so a lot of times what they'll try to do is they'll try to say, oh, well, you are an independent contractor for this home care, and, you know, we're going to give you 60 hours a week, but we're not going to pay you overtime.
Right. And so overtime is another important thing because just like collecting on the wage payment law, if you think that you're owed overtime, again, the first thing is, are you an employee or are you an independent contractor? And for, you know, every 40 hours in a week that you work, or over the 40 hours, you're owed time and a half. And that's, you know, a federal law. There are a lot of different industries where overtime differs. So like in the trucking or transportation industry, you really don't get overtime for safety reasons. The home care industry, there's actually many different kind of like subsections of qualification for overtime, especially if they're they stay overnight or they're live-in, things like that. Actually, software, technology, those industries, they also have their own separate overtime requirements.
Interesting.
So if you think that you are owed overtime, it's very important to talk to an attorney so that we can figure out what your profession is, if you are owed overtime, and we can help you.
Hey, everyone. Sorry for the interruption. If you found this information helpful or useful, please take a moment to like, share, and subscribe so that we could keep producing content and so that you get notifications next time there's an episode.
All right. Thanks, Anton from Kaminsky Law, and back to the episode. So it sounds like there's this really wild Venn diagram of all of these different contributing factors, right? The balancing test of what you're doing at the specific office that you work in or practice, the what industry you're in, and that being subject to different payment things, how you're being paid, how you're contracted. It's complicated. And so I think that where would we start? Like for you guys, where do you think the biggest opportunities or issues lie? Is it on the employee side? If somebody's listening to this right now and they're going, you know, hey, I need to go look at that. Or do you think on the employer side because you really are at that risk?
Well, I'm happy to speak to that. So I think it's both, right? And on the employer side, you want to classify people as 1099 when you can. And there's real situations where that makes sense. So let's say I hire a marketing company and I want a guy, or, you know, this is a perfect example. Let's say I hire a marketing company and it's not a company, it's just one guy, but he has his own marketing company. And he's going to work for me to make 5 videos, and that's all he's going to do for me. But he can go make 5 videos for somebody else. He could work for 100 people at a time. That person's not really my employee. That's a 1099. That's really a contractor. So he came in, he's doing a project for me. It's on a project basis. And it makes sense for that person to be characterized as a 1099. I shouldn't have to be responsible for his taxes. I shouldn't be paying him any benefits. He's got his own company, he's doing his own thing, and I have no problem with that. What typically happens from a employee standpoint is a lot of people just don't know the rules. And so when they go to start working for somebody, they get presented with this agreement that says, hey, you're an independent contractor and we're going to pay you $500 a week. And that's what it is. It's $100 a day. But sign this non-compete, which means you can't go work for anybody else. Come in here from 9 to 5, or maybe from 9 to 9, and it's not project based. You're just here doing whatever I tell you to do.
You can't do anything else.
Right, and you can't do anything else. But you're responsible for your own taxes, and you're indemnifying me from any liability and all this other things that go along with it. And then that's just an improper classification. But a lot of people, they need the job, so they're not arguing there. A lot of people just don't know any better, and so they deal with it. And sometimes, one of the scariest things when you don't know any better is if you really don't know any better. For instance, you're working for somebody, you're getting a paycheck, you're not thinking about setting aside money for taxes. When you work as a W-2, it's automatically set aside for you. It's, there's withholdings, you fill out how much you want withheld, the whole 9 yards. When you're 1099, if you made $1,000 a week, they pay you $1,000, and it's up to you to set aside $350 or how much ever you're going to get taxed at to make sure you can pay it later. And we've seen situations where people come to us and they say, hey, I made 60 grand last year. I didn't even understand that I was being paid as a 1099. They paid me 60 grand. I thought that's what I was getting paid. You know, maybe my English
now
isn't
I don't
great.
have any money to pay my taxes.
Yeah, now I just got a tax bill for $20,000 and I just don't have $20,000.
Right. And in that situation, so let's explore that. They come to you, 60 grand, I owe 20 grand in taxes. I didn't realize I was going to owe this, is the business potentially liable if let's say they were misclassified and now you guys step in? Does that employer need to understand that when you're doing that, if you get caught in that situation, that what happens? So,
that's when you would go into this balancing test. So let's say that employee came to us and said, hey, I'm liable for this $20,000 tax bill. I got paid as a 1099. Maybe it was improper. So we would look at the analysis. We would look at the facts, and that's why we always say facts matter. Everybody's situation is different. We can't tell you on a video how you should.
Sure.
But
this isn't legal advice.
Exactly. We start looking at facts, and we say, okay, did you bring your own equipment, or did you just show up at an office and use all of their equipment? Did you have a non-compete? Were you allowed to go work for 10 other companies, or were you working on a project based and, hey, this is the project I'm going to do for you and that's it? Or were you coming in and working 9 to 5 or whatever hours you were working? Did they control when and how you did your work versus, hey,
Right.
you could work anytime. If you want to work in the middle of the night, as long as you get this project done, I don't care when you do it or how you do it. Or do I need you here from 9 to 5? And if you leave at 4 o'clock, I'm writing you up. Right.
That sounds very much like an employee.
Right. And so if we get those factors and those factors weigh in favor of the person being an employee, well, then we'd reach out to the company and say, hey, you improperly classified them as a 1099. They're really a W-2, and you have exposure just like I have exposure, or just like this individual has exposure. And the way that the company has exposure is that they're not paying their fair share of taxes for that employee. Mm-hmm. So they potentially have liability to the Department of Labor, and they potentially have liability to the IRS. And that's when it really gets scary, because the IRS doesn't care, right? They're like, they come in and they say, okay, well, back in 2021, you did this. And so you owe penalties and interest on all those taxes that you should have paid in 2021 through 2025. Go ahead and write me a check.
So even in the worst case scenario, as we were positioning it here, this, employee, we realize employee passes the balancing test. They come to you. We reach out to the employer. Oh, there's that $20,000 tax liability in year 2025 we're in right now. Now people are looking at, because now this has been exposed. Now we're looking back 21, 20. You've been doing this for years, and the IRS is going, where's our money? And this could be a really serious situation. Do you see this, crippling businesses and causing real issues for them? Have you been on that side of this and seen that?
I haven't seen crippling at least yet, but I have had companies come to me and, they say, the Department of Labor called me. They said that I owe this employee this much. And, I go over the factors with them. I ask them about their, business practice, what they do. And a lot of times, it could be an issue. So you want to work with the labor board and negotiate and get that case closed before they come digging. Let's
explore that side of it, actually. Let's keep going on that. And I, the question that I kind of have is, I think there's always a way that an attorney is going to be able to step in and support you and provide guidance and help you navigate a situation like that. But is there to a certain extent, like if the balancing act is really clear and you're getting these calls from these employers and they're going, look, I don't know what to do. Can you help me? And you're looking, hey, it passed the balancing test. Not good. You've been doing it for a lot of years. Not good. Are you sometimes just going, you're screwed? Or is there what, or is there still a way that you can sort of support an employer that may have made this mistake either intentionally or unintentionally, and now they're looking for help?
We say you're screwed in a nice way, but we can help. We can, if it's one employee or a couple employees, they've made complaints and the Department of Labor has stepped in, we can fix that. We could, negotiate with them, figure out something, close those cases. And then we stay there and we can help you look at your all your employees. Who needs to be transferred to an employment contract or an employment agreement? Who needs to be paid on a W-2? Who really is an independent contractor that you can keep on a 1099? We always recommend to talk to an accountant because, we're not experts at that. So it's important that you talk to an accountant and make sure that you're paying properly. So yes, you might be liable to the few that brought up these complaints, but it doesn't mean that, going forward, your whole business is just going to crash and burn. We can help curb that and get you back on the right track.
The interesting thing, that the IRS and the Department of Labor, when you say, does it, ruin a business or can it bring a business down? The interesting thing is some people think that they can close a business and say, okay, well, this liability dies back then. I'm going to start over with a new business and everything's going to be great.
Right. They tell you that with an LLC, right? Open an LLC and you're totally protected.
Right. And so the interesting thing about the Department of Labor and the IRS, they don't care that your company is closed. So they're going after you personally. So you were the owner, or here's the 4 owners, or here's the 2 owners of the company, and you guys screwed up back in 2022. We don't care that your company's closed. We're suing you now. And so I know we had a video about this a long time ago about piercing the corporate veil, but that's when the government can pierce the corporate veil. And they just go, we don't care that you had an LLC set up. We're going after you because you should have paid those taxes and you really owe them to us.
And if it gets to the point where the employee is filing a lawsuit for lost wages, you can also be sued individually for that as well. The law does allow you to pierce the corporate veil and sue the president, the CEO, whoever is denying you your payment.
That's really fascinating. So I think it's really important that people understand you're really putting yourself at risk if you're not talking to an attorney up front, making sure that you are paying your employees correctly, because it will transcend the legal protections you think you have as a corporation. Ultimately, Uncle Sam wants their money. We've always known that, and they're going to get it if you get exposed. Let me ask you this: what are the So let's say I'm an employer. I'm listening to this podcast, or I'm watching this video, and I haven't. I'm thinking, okay, this. I think I'm doing everything right, but when do these usually crop up? Is it usually if there's an issue with the employee, like you described one, hey, I can't even pay my taxes at the end of the year. Why am I in this situation? What are some other circumstances that might come up? I guess firing somebody, I imagine you could do a wrongful termination, or claiming there's a wrongful termination, things like this come up. What are some areas where this comes up and presents?
Termination is definitely a big one.
Right.
Employees are terminated. They're upset. They want to figure out if they have any recourse. Another way it could come up is if your business is having financial troubles and they haven't paid their employees a paycheck in a couple weeks, or however long it takes for that employee to get tired of it and go on. Being treated just generally unfairly if they're facing harassment or something at work, or in their mind. Those are things that make an employee kind of sit up and go, what are my rights? And that's when the employer can find themselves in a little bit of trouble.
What typically happens is something the employer does pisses off an employee, and then the employee calls a lawyer, and the employee themselves might not even know that this is an issue. They start telling the lawyer, hey, here's all the things that are happening. And it'll be the lawyer that'll say, well, wait, how are they paying you? Or did they pay you, overtime? Or, so a lot of times it's aggrieved employees that get angry about something that is completely out of left field. They're calling a lawyer to see if they have any recourse. And then the lawyer will pick up
stuff.
Yeah, right. The lawyer will pick up on it. And that's actually an interesting segue if you want to go into it. Is, we get a lot of calls for, have I been wrongfully terminated? And I think that that's the second biggest category of employment litigation that we see is, have I been wrongfully terminated? And I think Aubrie should speak to that, because I think there's a lot of people out there with questions about that.
Yeah. What are some of I imagine anybody that gets terminated feels it's wrongful. So,
correct.
Yeah.
However, as I'm sure most people know, there's employment at will. And Pretty much all of the state. I think Montana may be one that doesn't have it.
Let's define that really quick, though, for
Sure.
folks that might not know. So what is at will?
Employment at will means that you can be fired at any time, but the side that they show as good for employees is you can quit at any time. But employment at will, generally benefits the employer more than the employee, and so you can be terminated at any time for anything, as long as it's not a discriminatory reason or retaliation. If you've been facing discrimination and you've made a complaint and then they terminate you, that could be retaliation. Other than discrimination and retaliation, it might be morally wrong and it might be terrible how it happened, but there might not be legal recourse.
So you hear a lot of, even though we're in an at-will state and most of the states are at-will, I think that a lot of employers are always worried that they're going to get hit with a retaliation from an employee because this is discrimination or this was retaliation. It sounds, the way you're describing, that a lot of those cases are going to fall flat and they're not actually going to be pursuable. But what should employers consider when they're letting somebody go? The assumption is they're doing things right and they're not doing it for discriminatory and retaliatory purposes. What should they do to protect themselves?
To summarize, before you get into it, employment at will means somebody could be fired for any reason and no reason, right? I could just come in one day and say, I don't like the way your shirt looks, you're fired. Or you smell like cigarettes, you're fired. And so an employer that wants to fire somebody, there's a couple of landmines, let's just say, that could trigger something. So there's age discrimination, which means, anybody over 40 is in a protected class. So if you fire somebody that's 60 and replace them with a 25-year-old, you might get sued. There's the protected classes, which is, sex, color, nationality, religion. I'm probably missing a couple off the top of my head. Maybe Aubrie can correct that. But again, if let's say you lay off 10 people and your company's got 100 people and every person you lay off is of one nationality or of one sex, you're probably going to get sued. There's a disability discrimination. So if somebody has some sort of disability and they come in and say, hey, I got to take medicine every day at 12 o'clock and, their eye drops and I can't see for the next half hour. So, I need an accommodation to have a lunch break at this time every single day. And you're like, I don't want to deal with that. You're fired. Those are the types of lawsuits that you're almost guaranteeing yourself a lawsuit. Mm-hmm. To protect yourself as an employer, you have to, keep these things in mind. And so if you're going to fire somebody that's 55 for a legitimate reason, maybe they're not doing a good job, and your intent is to replace them with somebody that's under 40 or substantially younger than them, you should document all the ways that they're not doing a good job.
Right.
And so a lot of companies, they'll have employment handbooks. One of the things that we say all the time is, do you have an employment handbook? What's your employment handbook say about this? If your employment handbook says that you're going to get, 3 warnings before we fire you, and then you fire somebody after the first warning,
you just breached your own handbook.
Right. And again, that's not binding law, but that's something that's more likely to get you sued.
Right.
Right? Because maybe the infraction is so bad on the first time that it warrants somebody being fired. So again, it's not a bright line rule every time, but these are things to consider. If you don't have an employment handbook and you just fire somebody, they might ask, did you have an employment handbook? Right? So there's constantly this back and forth, and I guess that's why we have lawyers and that's why people hate lawyers, is because there's this, it's like, well, I did it all the right way, but did you think of this?
Right.
And so but from an employer standpoint, one of the things we always say, especially as you get larger as a business, that you should have some sort of system. You should have some sort of systematic way that you approach things. When you have 5 employees, when you have 10 employees, it's not really reasonable for you to have HR, right? It's just going to be somebody that is the CEO or the president or the owner of the company. They're HR, essentially. Maybe they have a manager that helps them make those decisions, but that's it. When you have a company that's got 30 people, 50 people, 100 people, you probably should have a department that
manages these things
and oversees these things. And you really also want to have, and Aubrie brought up a good point earlier, is that you can get sued personally as the decision maker for, not paying wages. The same kind of thing goes for discrimination or retaliation. So the person that, knowingly or actively participates in the discrimination and the retaliation, they can get sued personally also. Mm-hmm. And so if you're the owner of the company, you really want to detach yourself from that. You want to say, okay, HR handles this. We have a performance improvement plan. We gave you a verbal warning on, October of 2024. You did okay for 2-3 months. Then in December, we had to give you a written warning. Right. And, you did okay for 2 months again. And now it's February and, you're just not living up to your skills, what we expect you to do, what we're paying you. And so if you've papered that well, and then you terminate that person, when a lawyer comes knocking, for whatever reason they're going to come knocking, because they will come knocking, you're going to say, well, wait a second, here's, exhibit A, B, and C of the things that we did right. And that will help you defend yourself. And then you take that to a lawyer like us from the employment side, and that's really what you want to do, because they're going to say you discriminated anyway. They're going to say you retaliated anyway.
Okay, quick question. When you're doing these 3 strikes, you're out sort of thing, is it baseball rules, 3 strikes you're out with these things, or is it lethal weapon rules? Do we go 1, 2, 3, go, or is it 1, 2, go on 3? Which is the?
It really is whatever you say it's going to be, and you don't really have to have 3 strikes either. You could have 1 strike, and if you catch somebody stealing, it could be no strikes. Hey, you stole from us, you're fired.
Right.
It doesn't. And we've worked on employment handbooks. We've put them together for companies that are getting a little bit bigger that need some sort of documentation and some sort of standards that they go by. And those employment handbooks will say things like that. They'll say, here's a list of things that are infractions that you can't do at work. You can't come to work drunk and high. You can't bring weapons to work. You can't threaten people at work. Maybe there's a dress code. You can't use your cell phone at work. Some places care. Some people.
This is assuming you
care.
don't work at like a gun shop dispensary sort of thing. But
Yeah,
that's
exactly. I don't think they want you coming to work high at a dispensary.
I don't know that they've done that combo business yet. It's a great idea. It's a great idea.
But we have those in the handbook, and the handbook will say something along the lines of, we can terminate you on the first infraction if it's bad enough. Sure. And so then you can always rely on that. But the thing that we tell employers to think about is really to keep it consistent, because, if you have 8 guys and 8 women working in a workplace, and for whatever reason, the guys get 3 warnings and the women get 1 warning, you're going to get sued.
Yeah.
Right. And so it's that kind of thing that you should always keep in mind as an employer, because that's the rules.
Yeah, so it doesn't really, your policies, how you handle infractions, things like that, don't matter as much as how you implement them. As long as you're implementing them fairly and across the board, you're generally okay. Juries love paper. They love seeing that evidence that they can hold in their hands on both sides. And so, if you have a performance plan and you've shown where they haven't met the metrics, that's going to weigh more in favor of the employer. Whereas if the employee has, emails or things like that, those are just things to kind of keep in mind, that juries just really focus on like the documentation of things.
And the one thing I would add to that, and that's a good point. And so when you give somebody, as an employer, when you give somebody a performance improvement plan of some sort, you want to have them sign it so that they don't say, well, I didn't see it. Right. And so here, we gave you this warning on whatever date. We reviewed it with you. We had a meeting with you. You signed it. When you have that meeting, you should have more than one person in the room. So it's not just 1-on-1, 2-on-1, 3-on-1, so that other people can say, I was in that meeting. This is what we talked about. From the employer's perspective. From the employee's perspective, don't just sign a performance improvement plan that gets put in front of you. If you have some sort of response, or you're saying, hey, well, I just reported that you guys were not paying me correctly, and
now you put me on this performance improvement plan. Right.
And now you put me on this performance improvement plan. If that's what's happening, you should write that right before you sign. That way, when the jury sees the document and it gets put in front of them, and you say, look, I told you about the retaliation back then, even before you fired me.
Right.
And so
that's a great tip, by the way. I think that a lot of employees are probably in a position where when you get a piece of paper like that, you don't feel like you're in a position, right? Your employer is telling you, we're not satisfied with X, Y, Z. It's an odd place to be as an employee to go, well, I'm not satisfied with ABC, right, at that time. But it's really important. That's a great note. I'd never heard that advice before.
And also, if you're sitting in a room, just from a psychological perspective, if I'm sitting in a room by myself and, I'm adversarial because I'm an attorney, but most people really aren't, and they want to just keep their jobs, right?
Right.
And so if I'm sitting in a room by myself and I have 3 people telling me how bad I am, I really am being pressured to just sign my name and give you this document back. And so maybe the response is, okay, let me take a look at this. Let me take it home. Let me talk, about it with my partner, and I'll bring it in signed tomorrow, right? So you don't feel like you have to sign on the spot. And if they are pressuring you to sign on the spot, well, maybe that's something you should voice and say, hey, I'm not comfortable signing on the spot. I have my own issues. Maybe you're comfortable voicing those issues to the 3 people in a room at the same time. Maybe you're not. So maybe you say, hey, look, I really need to take this home. I'll put in writing what my issues are.
And that's, we do get a lot of employees that call because usually those meetings are pre-scheduled and they kind of see what's coming. And so they call us and they ask us, what are my rights? What can I do? And that's the kind of advice that we can help give them. The other thing, Anton was saying, just don't sign whatever they give you. If you are terminated and they are offering you any type of severance package, don't sign it immediately. You're allowed, especially if you are over 40, you are guaranteed 21 days to review that and decide if you want to sign it or not. And then even after you sign it, you have 7 days to take it back. And severances, we always say, can be negotiated. And so you really want to talk to an attorney if you are offered any type of severance package and see, maybe you can increase the payout they're offering or the insurance, things like that. And the biggest reason to talk to an attorney is when you sign that severance, any lawsuit you have is gone. You are signing away your rights from the beginning of time until the day that you're terminated against the company. And so that is a huge right that you're giving up. And it's also a huge incentive for employers to come to the table and negotiate for severance because they want that waiver.
Let me ask you about that because I know that in recent years I think it's the federal government, but maybe stateside too, that is looking a little bit less fondly on non-competes, right? And they're reevaluating that, right? And I think that with some of the things that you saw out of just really nasty employment practices and also just like abuse and things like that were happening behind the scenes, that they're reevaluating that. So I want to be clear on that because I think that this is a little bit more or a bigger picture than what we're talking about in this video. But just to be clear, if I sign that agreement and let's say I felt like I was in an abusive or harassing environment, am I signing away my ability to come forward in that situation as well?
If you sign that severance, yes, there's going to be detailed language in there that says you're giving your any discriminatory or discrimination claims, any retaliation claims, even if you slipped and falled on the property, any of those claims, wow. You're admitting that you're paid up to date, that you're not missing any wages. And one of the things that you will sign on that severance is that you will, if you have a non-compete, that you'll abide by it and that you acknowledge that it's there. I know a lot of people know about the FTC taking down or, saying non-competes are unenforceable. There was a federal court ruling that I think it was the Ninth Circuit that could be unconstitutional. And so there's what's called a preliminary injunction right now. And so that law or rule, really as it is, doesn't go into effect right now. And so all non-competes are still valid in the sense that the employer can offer them and ask the employee to sign them, but there's still limits on those. Okay. And so you can have, usually your non-compete is like a year, 18 months, 2 years. Sometimes there's always a duration on it. And there's also a geographical location. And sometimes if your company is very specific and you have very specific competitors, maybe those are mentioned in the non-compete. Most courts, at least in Pennsylvania, don't look too fondly on non-competes, right. Especially if you're not a higher level manager, C-suite, those kinds of, if you're just, a lower level employee, or home care workers actually sign a lot of non-competes. And courts don't like to enforce those because it hampers their ability to
get
find a
other
job.
work. It's really tough though, right? I imagine those types of industries as well, because it's easier to go, let's say I'm thinking of maybe like even if you're in cleaning services, right? It's easier to kind of make a side agreement with the business that you're going to on a regular basis if you're an employer, independent contractor, and go, hey, you can cut out the middleman, just hire me directly. And so that's why those non-competes exist. I did have a quick question just on
let me touch on the non-competes, because I think Aubrie did a great job, but there's one thing that both employees and employers should think about on a non-compete basis. So the analysis is it reasonably suited to protect your interests? Okay, and that's a legal language. So let me unpack it. Do you really need it to protect your interests, or are you using it as an unfair hamper on competition? And that's really just the base that the courts are looking at. So let me give you an example.
Seems very easy to bright line that.
It
I'm
is
just using my legal terminology.
It is and it isn't, because in some cases it's very obvious. So in the home care space, it's very simple. Typically, the home care attendant is attending to their grandma, their mom, their aunt, some family member, or a friend. Okay? If you're going to sign a non-compete that says if you no longer work for this home care agency, you can't take your patient with you, that makes no sense whatsoever, because that patient wants you to be their home care attendant, whether you're working for agency A, B, or C. Mm-hmm. So we've gotten non-competes in the home care space just thrown out because it's absurd. You can't sign an agreement that says I'm not going to care for my mom anymore if I no longer work for this company.
Oh, interesting. So I was going to actually correct you on the pronoun you used there, because I didn't understand. So you're saying, just to be clear, this person is actually helping their own mom, and they're working in this home care agency, and they happen to be working in a home care agency, and now they're constricted by this non-compete that they can't support their own.
If they go to a different company, they can't take their mom with them. And that's absurd.
Okay.
Right?
And so
that's super
sense.
Unenforceable.
Right.
But let's do the flip side of that, right? You're a high-level marketing executive.
Can I pause you? Before you go to the next
ahead.
example, let's stay in the home care space, because I understood it from the opposite perspective. So, okay, if it's your own mom, ridiculous. We all agree. But let's say it's my home care, and I hire Aubrie, and she's working with this family that she would have never met before were it not for my connection. And then all of a sudden that family doesn't want to work with my business anymore, and they just work with Aubrie directly, right? Is that what those non-competes are there to protect? And where does that come in?
Yes. And I think that's a great example, and that's a great question. So typically, and that goes to the reasonably necessary to protect your business, right?
Because you're stealing the business, right?
Right.
Yeah.
So if I'm introducing you to people that you otherwise wouldn't have met, it is perfectly reasonable for me to say, hey, if you no longer work for me, these are my people that I introduce you to. You can't service them. You can't ask them for business. You can't work with them. You
Unless
can't take them somewhere else. Right. Right. And so, and it doesn't have to be your mom, right? Because there's a lot of industries where I have a book of business. And it's interesting because lawyers and doctors and accountants, their non-competes are pretty much unenforceable altogether. But if I have a book of business and I go from employer A to employer B, they want me, right? They want Anton or Aubrie. And if I go to a different company and I'm a lawyer for a different company, the employer can't say, well, you have to stay with me, because you get to pick your own professional. You get to pick your own doctor. You get to pick your own accountant. You get to pick your own lawyer. And so non-competes in that space are virtually unenforceable.
Fascinating.
But then there's that's almost like a bright line, but then there's a gray line. So let's say I am an insurance broker, and I have a book of business of companies that I've been doing insurance sales for a decade. And I come to you and, you get a taste of my insurance business, and you make me sign a non-compete. Well, before you sign that non-compete, if you came to a lawyer, I'd tell you to carve out those people that you're bringing in.
Right.
So yeah, maybe, or a non-solicitation, really. It's not really a non-compete as much as it's a non-solicitation. But I would say, okay, I brought you guys 10 clients that generate $1 million in revenue per year. I'm not letting you keep those if you fire me or if I leave. You guys can keep the ones that you introduced me to or that I gained while I was working for you, but those are my people.
Right. So you're talking about, I'm about to join a new firm. I bring a couple clients with me. You want to sign something to carve those out as the employee. As the employer, you're like, I brought you in here because you come with this very nice money bag of clients that, right? So interesting, but the protection isn't as much there on the employer side. If, you bring somebody up out of college, teach them everything, 10 years later, they build out a book of business, let's say as an attorney, and then they move on to their own practice or another place. Those clients can opt to follow that attorney, and that attorney's protected from being sued for stealing those clients. That's how that works.
For an attorney specifically. Okay. But there's some industries where that's not the case. So if you're a salesman for, insert product here, and you have been introduced to a client list, and they paid for you to go to trade shows, and they paid for you to
so that's not considered as much a service because you're selling. You're
selling.
Right,
you've developed a book of business. You've developed a series of relationships and connections. And then if you up and leave tomorrow and try to take those connections, those are the employer is right to try to protect those. And so there's an important line to be drawn between a non-compete and a non-solicitation.
Right.
And so that's one of the biggest things that people tend to conflate together. Mm-hmm. And the interesting thing about the FTC ruling, irrespective of whether it gets held up or not, is it only speaks to a non-compete. The FTC ruling doesn't like non-competes. What a non-compete says is that, you won't go across the street and start the same business.
Right.
Or you won't go up the street and start the same business. So they don't like that. They want people to
be able to do that.
Be free to compete. Right. A non-solicit is a little bit different. A non-solicit says you won't call on my clients. You won't call on my vendors. You won't call on my, suppliers. You won't call on my relationships. And those are still very enforceable. And so for the small businesses out there that want to make sure that their agreements are good for the next 5-10 years, irrespective of what the FTC does, they really want to make sure to make that distinction and really sit down and talk to somebody that can help them actually protect what they're looking to protect, and not just say, oh, it's a blanket non-compete, it's a blanket non-solicit, because the more targeted it is, the more likely it is to be upheld by a court.
I want to take the employer and I want to take the employee, and I want to give the top 5 things you should do right now. And you listen to this whole episode, you're like, okay, there was so much great information here. Top 5 things, maybe top 10, whatever you come up with that are in a list. Hey, if you're an employee or you're an independent contractor working for a company and you think you might be an employee, here are the 5 things you should do next. And maybe it's call a lawyer. But whatever you think those pieces are, and let's go through and kind of break those into chunks.
Let me jump in and give a couple of first thoughts, because there was a couple things I wanted to jump in earlier, but I didn't want to interrupt you guys. So the one thing you mentioned was the severance agreements. If you're getting terminated and you're in a high level position and you even think you're about to get terminated, you really should talk to a lawyer. You should talk to a lawyer way before that severance agreement gets put in front of you. If you think you're being discriminated or harassed or unfairly treated at work, in a way that we just discussed, you should talk to a lawyer ahead of time so that you start documenting things and start saying and writing the right things to your employer long before they terminated you, and now you're coming back and saying, oh wait, it's because of this and this reason.
It's really quick to that point. Let's say it's not for discriminatory purposes and all these. I know we're at will and all this different stuff, but let's say you're just on the bad end of the coin on a process of layoffs, right? Is there still things that, like you mentioned earlier, the negotiation around the severance being an option and things like that? Are there still things that you should be doing at that point, even if you don't think the company's doing this with malintent to protect yourself? Or if you really, you weren't harassed, you weren't discriminated against, the company may not be doing great and they're going through a round of layoffs, just take it and leave. Like,
I think
is
the
it
severance
only in the
is
cases?
Still negotiable. I think for a lot of times the company gets a lot of relief from you signing a severance agreement, like Aubrie mentioned before. There's a lot to it that you're releasing. So you're basically saying from the beginning of time until the moment you sign this agreement, we didn't do anything wrong. We paid you everything we were supposed to pay you. We never discriminated. You don't have any claims against us. So there's value in that for the company. And to Aubrey's point also is if you have other restrictive agreements with the company and you're about to get terminated, right? You might want to negotiate those. You're going to say, hey, wait a second. You're going to lay me off, but I have a 2-year non-compete. That doesn't make sense.
Right.
And so there's a lot of things that you might just wind up signing away to get, a 2-week paycheck that might not be worth signing. And so you really want to take a look at that, even if you're being fired for a good reason.
Okay.
So I think the overarching advice is you really should talk to an attorney before you sign those things, because we know what to look for. We know what we should ask for, and can give you that advice that can help you go forward.
Is there, I think and Anton and I have talked about this in the past, but as a business owner, if you're coming after a client for non-payment or things like that, there's always the worry of like retaliation and all these different things. Everybody's worried about retaliation. Is there a concern that, hey, you brought in this lawyer now we're going to pull the severance off the table? Does that happen? And
people worry about that. And look, it's a fair worry, because they are, it's this fear of something being taken away that is already presented to you. And we deal with that a lot. I think we deal with that a lot in all sorts of contexts. I mean, even in the shareholder disputes that you and I talked about, right? If a shareholder is being bought out and they have an offer on the table, there's this fear that if they come back and start to get too aggressive, then the whole doors are going to shut in their face.
Sure.
You have to really evaluate the big picture. You have to see what the situation is. And if you're being treated unfairly and you have your own levers to pull, or you have your own rights, I think you really should be thinking about protecting those. Another example of what you just said is, come talk to a lawyer when you're getting a severance agreement. Don't just sign it, right? At the same time, when you get an employment agreement, especially if you're a higher level employee, a lot of people will come in and say, oh, this has a 2-year non-compete. It's got a 2-year non-solicit. They don't even think about what the ramifications of not working for this company are going forward. They don't think what they're going to be paid for it to sit out of the industry for 2 years,
right,
or having to go litigate to establish that this is an unenforceable agreement.
It's like dating or marrying someone. You don't go into it going, it's not going to work out. You go
Right.
into it
Right.
thinking it will.
Right. And so you really should be thinking about that when you are even when you're just getting the job for the first time. You get this 20-page agreement, and a lot of people just sign it, right? They don't read it. They don't look at it. And then 4 years later, for whatever reason, you're going your own separate ways, and they're going, but wait
Right.
a second, you got to stay out of the industry for 2 years. And you're like, what do you mean I got to stay out? Well, you signed this 4 years ago or 10
Right.
years ago or whenever. And the interesting thing about the FTC ruling that we didn't bring up, and I think it's an important thing to add in, is that if you're getting paid over a certain salary, or if your role is in an executive or a decision-making kind of authority, and I think the salary is like $140,000, $150,000, something like that. If you're getting paid over 100 or 150, I think over 140 or over 150,000, and you're in an executive position, a non-compete is absolutely enforceable as to you. And so even with the FTC ruling in place,
Right.
and so that's another thing that people don't think about. Oh, well, the FTC said it doesn't matter. I'm just going to sign this. It'll be fine. And that's the example I was going to give you about, let's say I hire a marketing guy that knows all my marketing secrets, and he knows what my spend is and what I'm paying per click and what keywords
Right.
I'm bidding on. And then he's going to go work for my competitor tomorrow. I absolutely have the ability to restrict that.
Got it. Okay. And that in that space, we know that there's all kinds of things you can do with Google Ads and things like that that could really hurt the prior business. So it's very interesting. It sounds like there's a lot of different pieces and components you need to think about. I want to come back to, do we have our list ready? Do we have a list of our
You ready to go?
top 5? We don't have to do more than that. It could be top 3, but like, in these scenarios, let's hit it quickly. Like, and maybe I'll hit you this way. If you don't have one prepped, we can kind of go rapid fire.
Okay.
In the scenario of I'm getting fired or laid off and there's a severance package being presented to me, what are the first 3 things I should do?
You should read it yourself and kind of get an idea of what they're offering. You should talk to an attorney, and you should, if you have anything that you think is going to support any claim that you have on your work email or your work computer, you need to forward that to yourself. You want to have your documents with you somewhere personally, because you're going to lose access to that stuff as soon as you're terminated, and it's going to be a lot harder to get it.
You got to be careful about that. So one of the ways that you can get terminated from your company is if you forward confidential information to yourself. And so that could give them a separate grounds for termination. But there is an analysis, as there usually is in the legal world, where if you are doing it in a very limited basis and for the purpose of protecting your rights, then it's okay. But it shouldn't be, hey, I'm going to send this to my husband to make sure that I have these documents.
Right, I've been
for
flipping
later.
these documents for months to a personal account, and now you've been in breach of your agreement anyway. Okay, that's a good thing to know. But are there best practices? Is it like take a picture but don't email it to your husband, email it to yourself? Is it
I would screenshot things.
Okay. Yeah.
I would screenshot things rather than forwarding them out of like the corporate servers or whatever server you're on.
That's a good point.
I would screenshot it, maybe save it, and then save those files and just those limited screenshots. Don't go through and screenshot your emails for the last 2 years. Right. Just the things
that are relevant to what's going on.
Right.
Okay. Let's go with another example. Rapid fire. I'm an employer. I have a subsect of 1099s and W-2s. I think I'm doing everything right, but this video podcast kind of concerned me. What should I do? Go.
I think you should definitely talk to an accountant or a lawyer or maybe both. There's certain people and there's certain categorizations of jobs where it's perfectly normal for them to be 1099 and they probably should be 1099, but there's other categories of jobs where they are W-2. There's no question that they should be W-2 and you're probably doing it wrong.
Okay. Does it change, by the way? Like, I did this 5 years ago. I got my lawyer, I got my accountant, I got my doctor, I got everybody in. We looked. These are all my W-2s. These are my 1099s. We've grown by 20% each year. The business is good. I'm following the rules. Does it make sense to stress test that every so often?
I would stress test it. I would stress test it for at least the extremes or if somebody that's maybe a concern. Again, it's not a bright line rule, but for us as lawyers, I think it's very quick to see if somebody is improperly categorized. Okay. So
if you have a small business, it's good to have an attorney like us because we can answer those quick questions for you, or we can look at an agreement. We can help you with those things. So you're not doing some sort of in-depth detail every couple of years. You can just call us and you can
get those things relatively quickly. That's great. If I'm a 1099 contractor and I think I might be behaving like an employee, but I kind of like the situation I'm in. I'm able to do some side work and things are good. I'm happy with the circumstances. I'm paying my taxes and all those different things. But I'm hearing some of the things you guys are saying and I might be an employee. What happens then? I mean, if nobody makes a claim, is there no claim? Or is there still a liability there for either party?
Well, I don't want to give you legal advice on that issue, but sure. I think that if you are a 1099 and you're happy with being classified as a 1099 and the employer is classifying you as a 1099 and they're happy classifying you as a 1099, it probably won't raise any red flags. But if at some point a red flag does get raised or somebody gets into a dispute about it, chances are that they will come back and say, you improperly categorized yourself. We don't care that you liked it.
Right.
It's still, the employer, I think the driver of the whole thing is that in an employee relationship, the employer is supposed to contribute some portion of taxes themselves. So you actually, if you have somebody, the same exact person doing the same exact job for the company, and they're a 1099 versus a W-2.
Uncle Sam gets more on that W-2.
Uncle Sam gets more on that W-2 combined, because here we're both paying them and here only you're paying them.
Right.
And so Uncle Sam don't care, right? Uncle Sam don't care if you like it.
We got to make T-shirts.
Right. Uncle Sam don't care. And if you like it, if you guys are both happy, you're playing a risky game. And eventually if Uncle Sam finds out and says, wait a second, you guys should have been paying me this additional tax and you didn't.
That could be a huge issue. Got it.
Yeah.
I think that those are really great points, and I think those are good takeaways, right? Is there another one that either of you thought of that might be a good rapid fire stress test?
I would say rapid fire stress test, you get presented with a non-compete or non-solicitation agreement upon hire, go see a lawyer, because you're going to sign that thing and now you're bound. And the only way that you can get out of it is either A, your employer agrees to release you from it, B, you go to court and the court says that you're not bound by it. Otherwise, you're bound.
I just want to jump in real quick because a lot of our advice has been go see a lawyer, go see a lawyer, go see a lawyer. And I'm sure everyone is thinking, I don't want to pay a lawyer. And a lot of these claims that we've been talking about today, one of the relief in the statute is your attorney's fees. So there are cases where if you're not being paid properly, discrimination, things like that, you can get your attorney's fees back for them. And so we evaluate each case, and if we take it on contingency, we get a piece of what you ultimately receive, but you don't pay anything up front. And so I think that's really important for listeners to know.
That's really helpful, and that's only in the case though if you win, right? If the claimant wins, or is that, how does that?
So I would say yes. If you want every penny of your attorney's fees, you have to go all the way to the end, rule in your favor, and then the judge still has to say that they're reasonable. What they're really good for is a hammer for settlement. And so when you're talking to the employer, the employer is not, unless it's in your contract, the attorneys, they're not getting their attorney's fees back regardless. And so while the case goes on, their bill is going up and up, and they have the possibility of having to pay us our damages plus the attorney's fees. And so that's really where that comes into play.
So the risk is really higher for them in the long run, especially if there's any sort of gray area where they think they might not, clearly be in the right.
And to build on that, when you're suing an employer for not paying wages or not paying overtime, we would get our attorney's fees back. And so that is a hammer that would help us facilitate settlement. However, when you come in and you're a high-level employee and you're getting paid a lot of money and you've usually signed an agreement for that employment, a lot of times there will be a fee-shifting provision in that agreement. And what that'll say is that the winner of this lawsuit gets their attorney's fees. And so that doesn't necessarily now always put it on the employer. Now, if you've breached your non-compete, you've breached your non-solicitation, you're in breach of this agreement some other way, and now your employer sues you, you could be liable on the hook for their attorney's fees. And that acts as a hammer for the employer more so than it does for the employee, especially at a high level. And so that's another reason why before you sign these agreements, if you're an executive or VP level person, you really should have somebody look at them.
One last thing I want to cover is you talked earlier about when folks are calling you, an employee thinks they were wrongfully terminated, that a lot of times, because we're in at-will state, that may not be the case, but sometimes it is. I want to just walk us through what those calls are like. What's that process like if somebody wants to call Kaminsky Law and see if they have a claim? How do you guys handle that, and what does that experience feel like?
Sure. So our consultations are always free. It doesn't hurt to call. When you call, you're going to talk to our awesome paralegal, Becca, and she's going to get the overview of your situation. She has some questions that she'll ask, and then she'll send us a summary, and we'll look at it. And from there, we can really pinpoint what questions we need to ask to get the facts that we need to get to determine if it's a case. And then we'll call you back and we'll get those answers, and we'll decide, if there's something there. If there's something there, we can talk representation. Even if there's not something there, what I find is a lot of employees are, they feel closure after that. And so they know, at least I tried, at least I saw it through, and they don't have that what if lingering.
And even, go ahead.
The only thing I was going to add to that is don't hesitate to send Becca whatever screenshots and documents you have, whatever agreements you have, because that'll save you a follow-up call. So to be ready when you call us, have those screenshots, have that contract ready that you could just forward to Becca, and she'll make sure we all see it.
So if you think you might have some sort of claim, you're not sure, really important too, and we talked about don't forward those emails to somebody else or something that could be breach of a different agreement, but with your company. But just make sure you have whatever documentation you're able to collect, package that up in a nice clean package so that you guys can review it in that initial summary. And at the very least, even if you don't have a claim, we are in an at-will state, you get that closure of knowing that, yes, this is not a good situation if you're being let go from a firm, either for a layoff or firing, or termination, but at least you know that things were done on the up and up, that you did everything you could do to protect yourself and move forward.
Yeah, and don't hesitate to get a second opinion, right? Not all lawyers are the end-all, be-all Sometimes you call us and we say no, call somebody else, or vice versa. You call somebody else, they say no, don't hesitate to call us. So I know that goes against the closure a little bit,
Right.
but you go to a doctor, they give you a diagnosis. You're like, I don't like that diagnosis. I need a second opinion. Don't hesitate to do that in the legal space either.
Yeah.
That actually brings up a separate question. Let's hit this really quick. Employers are always freaked out by this idea of a frivolous lawsuit, right? That, and especially if you're in an agreement situation where our attorney's fees are going to go up and they're only, they're on a contingency, so they don't care and they're just going to keep working until they get a settlement or whatever. For folks that might be coming forward with a claim, this might be an odd question, but if coming forward with a claim and you might suspect that your attorney is just dragging these things out and just trying to push forward a frivolous claim. Presuming you're a decent person that isn't supporting that, what are the indicators that might be happening? I know this is kind of an odd question. I never thought of this before. But
so we do, and to answer your question, there is this statute in Pennsylvania. It's called the Dragonetti Act. And what that does is it prevents frivolous lawsuits. And so one of the things that you can get hit with as an attorney and as a person pursuing a lawsuit that's frivolous, and to define frivolous, there's no factual or legal support for it.
No bright line.
There's not a bright line, but there's some very obvious cases.
Yeah.
And so there is a likelihood. People don't go after attorneys for suing often, but if it's bad enough, people have been sued for Dragonetti. And, people will go after lawyers for Dragonetti. And one of the things that we do when our clients are subject to this is we'll send a Dragonetti notice early in the lawsuit. And it'll say, if it turns out that your claim is frivolous and you're pursuing it knowing that it was frivolous and we win, when we win, we will sue you.
We're going to keep coming.
And that will often also help facilitate settlement as a hammer, because if a lawyer knows that their claim's not good, but it's based on real grounds, they don't have to worry about that. But if a lawyer knows that their claim is trash and they really don't have any support for it, if we get it knocked out, there is a chance that they get sued.
Yeah.
And so we haven't had to sue people for that. At my old law firm, they used to love suing people for that. And so I have a lot of experience doing it. So if we ever have to, I'm ready to go.
That's interesting. So, yeah, go ahead.
You should also be careful when you're talking to an attorney, when they're offering contingency, how much they're offering to take, because there is a point where it gets unethical. If they're taking 40, 45, 50%, if they're taking 50% or more, you need to go to a different attorney. Got
it. So those are really, it sounds like, the key characteristics. And I want to hit this one more time. So if it's too high of a contingency, that could be a red flag. I'm thinking of a scenario where, you called the attorney, you're like, I don't know if I have a claim here. And you've got one of these, Dragonetti sounds like an old martial arts studio, like the Dragonettis versus the whatever. And there's like an old Bruce Lee thing going. But if I'm hiring an attorney in good faith and they're going on this contingency, maybe it's a reasonable contingency or a little slightly higher than it should be, and they're pursuing this case, I don't know that they're doing these things unethically, right? Like I'm just, hey, here's my information. Do I have a case? Are there key factors there that you would go, like, these are the things I would look out for? Or is it really just...
I think as you get further down the lawsuit, and this might be a whole separate video or conversation that we do, but as you get further down the lawsuit, I think it becomes painfully obvious when you don't have a case. We've had a couple of cases thrown out, for instance, at the deposition stage, right? The person is in the deposition. The lawyer, we as the lawyers ask them some questions, and this is on the other side. We ask them some questions, and it turns out that the lawyer said one thing, but the person's saying a different thing, and it's like, which is it?
Right.
Right? And if it's with a thing that the person just admitted to under oath, then you have no claim. And we've gotten a lawsuit dismissed, a week after the deposition before on that Dragonetti threat, right? Yeah. Like, okay, you brought this lawsuit. Maybe it had grounds if the things you were saying were true. Now you know the things you're saying are not true. Get out of here.
Get out of here. Got it. Okay. So that's really good to know, and something maybe we'll cover in another episode. Yeah. That's great. I think that this was a really good discussion around employment law practice, your employment law practice, and the way that you work with employers and employees to make sure that they're doing things on the up and up and being taken care of. So thank you both, Aubrie and Anton, for being here. And
thank you.
Check out Kaminsky Law if you have any questions.
Thank you.
Thanks.